Hi, my name is Carl Pearson, and I'm an attorney in New York, spending most of my time since 2008 defending mortgages against foreclosure actions commenced by banks, servicers, vulture funds, and others. This video is somewhat complicated and is going to discuss New York's 6-year statute of limitations and certain issues being raised by mortgagors and also by mortgagees to try to take advantage of, or in the case of mortgagees, to defeat the statute of limitations. The key words used to discover the issues or to discuss the issues are statute of limitations, acceleration, and deacceleration. I'll cover these words at length in a few moments. If you have any concerns about the statute of limitations regarding your unpaid mortgage, you need to put some information together. It would be helpful to me and other foreclosure defense attorneys if prospective clients could provide during the initial discussion of their problems the following information: the date of commencement and index number of each lawsuit commenced against them as to the same note and mortgage. 2. The date of each loan modification agreement and the number of any trial payments and the number of any payments made on the permanent modification agreement after any trial payments were made. And 3. The dates and types of any bankruptcy filings, the index numbers, and a brief discussion of what happened during bankruptcy. Now, those are the things that you should be providing to an attorney so that the attorney can help you immediately. But here are some things that you should remember in order to understand what I'm going to say later on in this video. There are 4 basic rules for you to remember. Basic rule number 1, non-payment of a note and mortgage for 6 years with no foreclosure action by the lender or servicer raises the defense in New York of the 6-year statute of limitations. Second basic rule, any payment on the mortgage other than trial payments on loan modification agreements stops the 6-year period from running and prevents the defense of the statute of limitations. Basic rule number 3, no lender or servicer will accept any mortgage payment after it has commenced a foreclosure action because acceptance of the payment would eliminate the acceleration of the debt required to maintain the foreclosure action. And finally, basic rule number 4, trial payments on a loan modification agreement are not payments on the mortgage, and that's by agreement. And do not waive the homeowner's default. That's also by agreement. And do not appear as payments on the mortgage thereafter. They go into a banking limbo, but are sometimes, and I think improperly, pulled out of limbo by the banks by unilateral credit to the mortgagor to function arguably for them as a de facto and often retroactive letter of deacceleration, which is something which would be adverse to the homeowner. Now, with all of this in mind, let us begin by discussing the 6-year New York statute of limitations. Please remember that we are now in the year 2016 or 2017. Many homeowners start off with a misunderstanding of how the statute of limitations is applied. Let me give some examples. A foreclosure action commenced in 2008 is still pending for 8 years. The statute of limitations situation is not improved for the homeowner because the action commenced in 2008 on a timely basis is still pending, even though there's been no payments at all, because any payments, as you know, would eliminate the foreclosure action. So there were no payments, but that doesn't change the fact that the action was brought on a timely basis, and therefore there's no defense of the statute of limitations. 2. If the same 2008 foreclosure action was subsequently dismissed or discontinued, let's say in 2009, the owner of the note and mortgage would be barred from suing on the note and mortgage under the 6-year statute of limitations in 2000. 14, 15, 16. The same, this is number 3, the same would be true if the action was dismissed or discontinued in 2015, because the 6-year period started no later than the date of commencement of the foreclosure action back in 2008. Now those are some additional basic things for you to know. It does not work if a single lawsuit has been brought on the note and mortgage within the 6-year period. Many homeowners make this error when trying to understand the statute of limitations. If only one action has been commenced and it was commenced prior to the end of the 6 years of non-payment, and if the action is still in existence and has not been dismissed or discontinued, the homeowner has no statute of limitations issue or defense to pursue. What is needed is a discontinuance or dismissal without prejudice of the original lawsuit, followed by another lawsuit on the same note and mortgage. It makes no difference whether there is a different bank, plaintiff, or servicer, as long as the note and mortgage are the same. If the second lawsuit is commenced fewer than 6 years after commencement of the first lawsuit, there is no issue for the homeowner. But if the second action is commenced more than 6 years after commencement of the first lawsuit, the homeowner would be entitled to a dismissal of the action and a judgment that the property is not subject to the note and mortgage. This now brings us to an interesting concept, a letter of acceleration. Back in 2008, lenders and servicers sometimes sent a letter to a homeowner in default stating in substance that, quote, your loan is now accelerated and you owe the whole amount of the loan including the unpaid principal, unquote. If any such statement was sent, the loan was accelerated on the date of the letter, which generally preceded a foreclosure action. The date of any such letter of acceleration starts the 6-year period, not the subsequent filing date of the foreclosure action on the note and mortgage. If you can find any such letter, it could enable you to win your home free and clear of the note and mortgage. when the lender, without recalling the letter, relies on the filing date of a first foreclosure action for the start of a 6-year period. This often can happen because of the number of times that a note changes hands, and the fact that there was a letter many, many years ago would not necessarily be part of the record that would be maintained by the newest owner of the note. Warning: the lenders then and now often sent out letters threatening to accelerate the loan if the homeowner fails to bring the loan up to date. These letters generally are not letters of acceleration, although defense attorneys may argue, and I have too, that the wording of some letters makes them letters of acceleration instead of mere threats of acceleration. Now, you should have a basic understanding of the statute of limitations and the concept of acceleration of the debt. We can now discuss deacceleration of the debt. This is a two-edged sword, with homeowners in bankruptcy arguing for their right to deaccelerate an already accelerated mortgage loan, and with bank servicers and other note owners arguing in the state courts for deacceleration, and you'll see also the homeowner in some instances. In 1982, the Second Circuit Court of Appeals in New York, in the case In Re Taddeo, 685 Fed 2nd 24, upheld the right of bankruptcy courts to cure and reinstate a mortgage loan that had already been accelerated in the state court, requiring the homeowner to pay off the entire principal amount of the loan, as long as the property had not been sold pursuant to a state court judgment of foreclosure and sale, and provided that the bankruptcy petition had been filed within a reasonable length of time. This was allowed by the bankruptcy court, stating that the accelerated loan was now deaccelerated with only the unpaid monthly payments due and not the principal amount. The Second Circuit said this result was helpful to get the parties to negotiate a settlement in good faith. Thus, deacceleration worked in favor of the homeowner if the homeowner was in bankruptcy, by enabling the bankruptcy court to reinstate a mortgage after its default and acceleration under state law, thereby saving the property for the homeowner. Later bankruptcy courts have modified the monthly payments. On the other hand, the lender or servicer or note owner, when facing a 6-year statute of limitations defense because of the past filing of a foreclosure action, say in 2008 or 2009, but subsequently dismissed or discontinued without prejudice, or an earlier letter of acceleration, may try to avoid the defense by 1. Issuing a letter of deacceleration before or after expiration of the 6-year period, or 2. Referring to any deacceleration in the bankruptcy court and arguing that the statute of limitations stopped running and that payments to the bankruptcy court stopped the 6-year statute from starting up again until payments were stopped once again. The issuance of a letter of deacceleration is a new technique now being used by lenders in foreclosure actions to try to get around the defense of the statute of limitations. The lenders are claiming they have a right, after accelerating a mortgage debt, to deaccelerate the debt and stop the statute of limitations from running any further. And in some cases, they are trying to get the court to let them deaccelerate a debt even after the 6-year period has expired. In my opinion, these efforts at unilateral deacceleration by the lender or servicer are inconsistent with the legal consequences of their initial foreclosure action and should be rejected under state law. The second type, involving a homeowner's deacceleration in the bankruptcy court, is something which needs to be carefully developed from the bankruptcy court record, and if applicable at all, should be limited in duration to the time in bankruptcy and not a total deacceleration for all purposes. The state law is not clear on the interplay between bankruptcy deacceleration, which failed to work out and wound up in state court foreclosure proceedings anyway. There appears to be no case law on this issue in New York. Another matter to be considered under New York law, CPLR 3408F, which requires a lender or servicer during the mediation period starting off a foreclosure action called conferencing to negotiate with a homeowner in good faith as to all loss mitigation options, which generally are 1. A HAMP or in-house loan modification agreement, 2. A short sale, 3. A deed in lieu of foreclosure, 4. Walking away or key money to leave the premises broom clean, 5. Pay off the defaulted note, 6. Purchase of the defaulted note at a discount, and 7, I would add the following: a deacceleration of the loan with the homeowner being allowed a reasonable period of time to catch up on his missed mortgage payments while continuing to make his future mortgage payments and not being required to pay the principal. Or 8, a deacceleration plan comparable to what a Chapter 11 or Chapter 13 bankruptcy plan would provide. And this would be the most controversial, but I think should be argued in conferencing as a matter of good faith negotiations. The court cannot impose any of 1 through 8 on the lender or servicer, but can impose certain costs on a lender or servicer who, acting in bad faith, does not agree to what a homeowner wants to do as to loss mitigation. This is all very complicated, I understand, but I wanted to have clients and others understand some of what a defense attorney is considering so that less time can be spent discussing the foregoing, which will make foreclosure defense less costly and more effective for homeowners and others facing foreclosure. What I have discussed may apply in other judicial foreclosure states, but needs to have appropriate legal research performed to determine to what extent. There are 190 decisions in the United States, 30 of which are from New York, with the words deaccelerate and foreclosure in the decisions. If you have any comments or questions, please send me an email with the phrase video 134 in the subject line and I'll try to respond. My email address is carlpers2@gmail.com. That's CARLPERS2@gmail.com. I look forward to hearing from you.